again. Same rules as last year apply. I'm here to answer your questions, so feel free to ask me whatever questions you have, whether they're on topic or off topic, during the hour that we have. I do want to tell you that there's no need to come to the next meeting, because I know what keeps CFOs up at night, and that's employment law issues. So this is me. You've got this all in your materials. What we're going to talk about today, and it's very interesting because what I wanted to do was to give you an update on what are current issues, what's been changed in the law, what's a hot topic, things of the sort. And I was talking to Jim, and I said that's what I was going to do, and he said, oh yeah, things like background checks. So he's my straight man because that's the first thing that I had on my list today. So we're going to talk about background checks, changes in the law with respect to background checks. We're going to talk about the topic of criminal convictions and arrests, a little bit about things like lying on resumes, a tinge about domestic violence, a little bit more about social media issues, which are becoming a very, very hot topic. A little bit about discrimination law, and I want to alert you to a couple of cases that are fascinating and somewhat counterintuitive. Just remind you about audits and records, which are always an issue, and if we have time, talk about the dichotomy in same-sex benefits issues because of the New York State law permitting same-sex marriages, but the Federal Defense of Marriage Act. So it's a long agenda. If we get through it, great. If we don't get through it, then I'll come back next year. So what's new with respect to background checks? There's a number of years ago, there was a statute called the Fair Credit Reporting Act that was enacted to regulate credit reports. And that statute became applicable to doing background checks for employees. And basically what it says is if you're going to have a third party doing a background check, you have to comply with the statute. So that means that you have to get an effective release from the employee agreeing to the background check, and if there's something that's inappropriate in the background check, then you need to go through some procedures in alerting the employee to that. That statute has been amended, and there's new rules that are effective January 1st, 2013 that we will briefly discuss. The other thing that's happening in that area is we've seen a proliferation of class actions with respect to third-party background checks, that they were done inappropriately or that the releases were not satisfactory. So what the statute requires is, the one thing that's happened is that the enforcement agency used to be the FTC, and there's been a new enforcement agency created, which is the Consumer Financial Protection Board. What that means is that because there's a designated or a particular agency whose function it is to regulate the Fair Credit Reporting Act, we're anticipating that there's going to be more scrutiny with respect to compliance in the background check area. So it's a hot area, it's an area you need to look at. How do you comply with it? If you're going to use a third party to conduct an investigation, then what you need to do is you need to obtain a particular authorization from the employee. That has to be on a separate form. It can be attached to a job application, but it has to be on a separate page. I have actually jerry-rigged it a little bit to make sure that it complies with both state and federal requirements. But the forms that you used on December 31st are not the same forms that you should be using on January 1st. So you need to change the forms and the name of the regulatory agency. If there's something that comes up on the background check that is negative, then you have to provide the employee with a notice, including the notice of the employee's rights. And the employer has to certify that the employer has complied with the Fair Credit Reporting Act by notifying the applicant or the employee, by obtaining permission, and of course you can't discriminate against somebody because of the criminal conviction or misuse the information. And that leads us into the next topic, which is, well then, when can you use information about arrests or criminal convictions?
Sharon, you can't discriminate against a criminal? You can't say, I'm not going to hire you because, like, you're a convicted felon.
You want to be my straight man instead of Jim, is that it?
I'm like, sorry, I just, like, that's amazing to me.
There's actually a dichotomy. And the dichotomy is that, on the one hand, New York has a public policy that people who have been convicted of crimes should be able to be rehabilitated. And therefore, you shouldn't have a blanket rule, and it's true, you cannot have a blanket rule in New York that prohibits hiring somebody who's been convicted of a crime. On the other hand, New York recognizes that you need to protect your business. So there's this conflict, and I'll walk you through how you deal with that conflict. And what's happened in the past 10 or 12 years, and Bridget and I were talking about this because Bridget works with an agency that is involved in childcare. And there are certain industries that are more protected under the statutes. So with those industries, the law requires that there be fingerprints taken and that there be record checks. And the state tells you who you can hire and who you can't hire. It actually makes it a little bit easier, doesn't it, Bridget?
Well, it does, and well, it does if it's obvious that they can't hire. Usually, when somebody is flagged, the state doesn't even tell us what they're flagged for until after the fact. But yeah, they'll come in and they'll interview and they'll say yes or no.
But aside from those regulated industries, and there are more mandated background checks each year, there are more mandated background checks. But most of the industries don't have mandated background checks, which means that you make a choice about whether you want to get a background check on an individual or not. And that's where it becomes difficult, because if you do a background check, and you then find that the individual has a criminal conviction, the question is, what do you do with it? So you have to go through an analysis that's required by the statute with respect to the criminal conviction. The dichotomy is, on the one hand, you can't discriminate against somebody based on a criminal conviction. On the other hand, if you say, okay, the law says I can't discriminate against somebody based on a criminal conviction, I'm going to ignore the criminal conviction, you face a potential, if something happens as a result of the criminal conviction, of a claim of negligent hiring. So it's a very difficult decision. You thought I was going to give you good news, huh?
Still waiting for it.
It's a very, very difficult decision. So the basic rule in New York is you can't fingerprint employees, you can't discriminate based on a criminal conviction. The other side of the rule is that if the criminal conviction is reasonably related to a person's job duties, then you can refuse to hire somebody based on the criminal conviction. And in the mandated, regulated industries, you can fingerprint. What do we mean when we talk about negligent hiring? What's an illustration of some of the cases? I want to start with the case that I've got in the middle here under negligent hiring. And that was a case where New York City got nailed for a large $2.5 million. And the case was quite a while ago, so that was real money back then. $2.5 million damage award for hiring somebody who had a sex offender conviction and putting that person unsupervised in a park where children played. There was a rape, and obviously everybody said to the city, you knew or should have known of this person's propensities. And when you look at the recidivism rate with respect to sexual offenders, and particularly child predators, it's a very high recidivism rate. On the other hand, it was held that there was no duty for a diocese to inquire about the background of priests. But again, if you know that somebody's a pedophile, then you have a duty to take some action. So that's the dichotomy. That's the first question you always have to ask in deciding to do background checks is, do you really want to do it, and do you want to be bound then to take some action as a result of what you find in the background check? It's the same thing with drug testing. Not mandatory that you do post-employment, pre-offer, post-offer, pre-employment drug testing. But if you decide to do it, then you need to be prepared to take some action if somebody comes up with a positive test result. So if you make the decision to conduct a background check, then New York regulates what you have to do. That's in Article 23A of the Corrections Law. I had a really interesting situation this year because I was asked to testify as an expert witness in Brooklyn Criminal Court. And you might say, well, you're an employment lawyer. Why are you testifying as an expert witness in Brooklyn Criminal Court? And what I was testifying about was that there was an individual who had already been convicted of a crime that involved larceny. And the question that the judge was interested in was what impact would this have on her employment? Was it likely that her employers would terminate her? And if so, the judge was going to set aside her sentence. It was a family-related affair, it was kind of a minor offense, but it was still a petty larceny conviction. And so the judge wanted me to go through the rules that I'm going to go through with you with respect to what an employer has to do in analyzing the impact of a criminal conviction, and then he asked the question about what it was likely that the employer would do, which of course I couldn't answer. So first of all, if it's a criminal arrest that has been adjudicated in favor of the employee, you can't ask about it, you can't do anything about it. An arrest is nothing, it's only an arrest. You may be able to take action based on the underlying facts. So let's say an employee was arrested, the employee comes into you and says, before you read about the arrest, I want to tell you I beat up my spouse, or something of the sort. You can take action on those underlying facts, but not on the basis of the arrest. Now the person goes to court. Let me back up. Interestingly enough, the Equal Employment Opportunity Commission, which is the federal agency that deals with discrimination cases, has agreed that you cannot take action based on an arrest. And one of the bases for that is that the EEOC says that that is race discrimination, because it has a disparate impact on certain races to take action based upon an arrest record. Why did you leave your previous place of employment? Good behavior. They cut time off my sentence. Okay, so this is what you have to do. The New York Corrections Law requires that you go through an analysis. And the analysis contains a number of factors, and you really have to reach all of the factors. So when you find out that somebody has a criminal conviction, you need to find out how old the criminal conviction was, how old the person was at the time of the criminal conviction, whether the criminal conviction is reasonably related to the person's job duties, any other information, were they given a certificate of good conduct, and then you need to determine whether the criminal conviction is reasonably related to the person's job duties or to protection of persons or property. If that's the case, you can refuse to hire the person as a result of the criminal conviction. If that's not the case, then you can't. And sometimes it's counterintuitive. So let me give you an example. Individual is going to be hired in your, Jim, give me a position that you supervise.
Payroll.
Okay, payroll clerk. Person is applying for a position as payroll clerk. It turns out they have a petty larceny conviction on their record. That's fairly recent. Can you refuse to hire them based on that?
I would say yes.
Yeah, I would say yes too. So if somebody called me up, and I love it when people call me up before and say, what should I do, as opposed to calling me up after saying, this is what I did I do it right? Which is what they do all the time. So call me up and they say, can I do it under those circumstances? I would say, look, can you trust that person if they've been convicted of petty larceny? Probably not. Therefore, it is reasonably related, therefore you don't need to hire them. Now what if that person who's applying for the payroll position had been convicted of murder and incarcerated for the past 30 years and is just getting out?
Could be different.
You can't refuse it.
Yeah, that's a much more difficult issue, isn't it? because it's not reasonably related to the job duties. And it's not necessary for protection of persons or property. There can be such a thing as a rehabilitated murderer, and actually, if you look at the recidivism rates for people who commit homicides, and maybe that's because they're incarcerated for long periods of time,
It helped them.
but the recidivism rates are pretty low. Another example, let's say somebody is convicted of somebody's convicted of assault, which is most often a misdemeanor. You operate a hotel motel. This person is being hired or is seeking employment as a room cleaner, whatever they call them now. Okay? You tell me. How many of you think that when you call me up, I'm going to tell you that you can refuse to hire that person to go into people's rooms and clean their rooms? Let's say it's a recent conviction. How many of you think you cannot hire that person? Raise your hands up high. Hi, I want to see a committed audience, even though it's early in the morning. Okay, how many of you think that you can not refuse to hire that person?
I think it was an old conviction.
Okay, so it's overwhelmingly in favor of refusing to hire that person, and I think the better course in that situation would be to refuse to hire the person, because that person goes into rooms, sometimes people are in rooms, and you have a duty to protect your patrons, the people who are in the rooms. Now let's change the facts a little bit. Let's say that the position that the person is seeking is as a dishwasher. What do you think? Hire or not hire? Hire?
Higher.
Right. I think it's a different situation.
Right.
So these are illustrations of the analysis that you have to go through.
Can I ask you something? Can I give you an example of my business? I'm a not-for-profit school.
Sure, but I'm going to give you a disclaimer that nothing here constitutes
No, I'm just giving you.
Can't run with it.
You have the right to remain silent. You're being
No.
videotaped.
I'm not worried about that. Just we're mandated to fingerprint, and we fingerprint because we're under the auspices of many different governmental agencies, so we're mandated into different places. But it's interesting because, for instance, I had somebody come in for a maintenance position a long time ago, and cleared through one government agency, not cleared through the other government agency, and it was a DWI conviction. They couldn't really not clear him for that because it has nothing to do with what you're saying is really has nothing to do with what his job responsibilities were.
Yeah, I mean, I think you have a defense if he's not cleared through the government agency. You really have no choice.
Right.
But if it was a private employer situation, I would probably say that the DWI was not reasonably related to the job duties.
One agency cleared.
Yeah.
Other agency
Yeah.
wouldn't.
Yep. But I would say that it's not reasonably related to the job duties. You said he's a maintenance person.
Right.
And unless he has to drive for a living. And then one of the other issues sometimes that you need to address with respect to some industries is whether, in view of the criminal conviction, the person can get bonded or you can get insurance. That's always something that you should look at. But these are difficult issues. These are really difficult issues. And unlike most situations, we said last year that the general rule in New York is that all employees are employed at will, can be hired or fired for any reason or no reason at all unless it's a discriminatory reason, which is where these protections come in. Usually you don't have to tell somebody why you're not hiring them. In this particular situation, because of a New York statute, if the person asks to be told the reason why they are not being hired, you are required to do it. You're also required to have, if you look at your posters as of about 2 years ago, you're required to have a notice of these rights under Article 23A of the Corrections Law. So if your work-related posters are not up to date, they need to be brought up to date by having a copy of this provision of the law. Now here are some of the practical questions that I see all the time. You have an individual who lies on their resume. Have you ever been convicted of a crime? And they say no. You find out later on that they've been convicted of a crime. Can you terminate them on that basis? And the answer is an absolute yes. In fact, I'm litigating a case right now, and I won't get into all of the facts, but It turns out that somebody was hired as a controller of an organization. They were terminated for other reasons, and as part of the due diligence done during litigation when they sued as a result of their termination, the employer discovered that this person had been convicted of fraud-related crimes in another jurisdiction. And above and beyond that, during the litigation of the fraud-related claims, the individual had started harassing the judge, which shows not good judgment on the person's part. That's what you call after-acquired evidence, and the employer would have been justified in terminating that person who represented that he hadn't been convicted of a crime, no matter what, and it's also a defense in this litigation. So it's an easy question if somebody lies on their resume.
This
Yes.
may go the way of urban legends, but you hear people say that on a resume, you can do things, but on an employment application, it better be, that that's a legal document, quote unquote, and you have to be very scrupulous about what you put there. Is that fallacious, that the resume is just as...
That's a great question. I really like that question. I think anything that the employee represents to the employer, if they falsely represent it, then it's going to be grounds for termination. However, it certainly helps to have a little statement on your employment application that says, I certify that everything that I've said in this application is true.
I think you said that. It's basically a representation of yourself.
Yeah, sure. Yeah, and and if you really, I'm sorry, one second, if you really want to be inclusive, change that certification that I just provided to, I certify that everything that I've said on this application and all documents that I've presented to the employer are true.
Thank
Yes.
you.
To take that a step further, you mentioned social media before. Where does LinkedIn and things like that come into
Okay,
play as well?
hold that question, but remember it when we talk about social media, because it's just a fascinating, wide open area. And I want to talk about whether you can even look at that stuff on social media. But then the second question is what they represent to you versus what they represent on social media. So we'll get back to that. What about if your employee is arrested and they call you and say, I need to be bailed out? Should you bail out the employee? And if you bail out the employee, can you deduct the bail payments from their wages? How many of you think you should ever bail out an employee? No. And I have a lot of small businesses that I represent, and they want to be nice and they want to do this stuff. And you just can't. You can't do it. It's just mixing personal and employment, and there's no legal prohibition, but how are you ever going to get the money back? How are you ever going to assure it? And you're going to overlook stuff at work because now you've got a monetary investment in this person. It's just not a good idea. And the answer to can you deduct the money that you've paid for the bail bond from their wages is absolutely not. We'll talk about deductions from wages in a minute. Substance abuse at work. Let's use this criminal conviction. You've got somebody, or an arrest. Somebody's arrested for a crime, drug possession, something of the sort. Or somebody comes into your office and says, I don't want you to tell anybody or do anything about this, but, it's what they often say, but I believe that so-and-so is under the influence of drugs. What do you do? It's a much longer topic. We can schedule that for another time, but basically, it doesn't really matter why somebody is not performing accurately. What you need to do is you need to make all of your decisions based on performance. And if you make all of your decisions based on performance, you will be okay. Employee fights. What happens if employees get in fights at work? It's got to be an improper, that's improper conduct. You take action against both of them. You're running a business, you're not running a boxing ring, and employees should not be doing these things. I think that's a pretty easy case. What about you find out about an arrest? What should you be saying to other employees? Somebody's arrested for homicide, assault, rape. What should you be saying to other employees? And the answer to that is nothing. Nothing. You don't have a duty to protect somebody based on an arrest. An arrest is only an accusation. And here's, yes.
So on the substance abuse, unless the employee is underperforming, you don't have an obligation to take it to counsel, of corporate counsel or anything like that.
No, and you know, you may have programs yourself. You may have information available for employees that's equally available to all employees for substance abuse programs, but you're going to have issues if you yourself label somebody as a substance abuser.
Right.
So you only take action based on the performance.
I have a question on that.
Sure.
In our work, our executive director had created a policy that they have to sign stating that if there's any suspicion,
Drug-free
they have
workplace.
to, yes, they have
Yep.
to submit to.
Okay, that's testing. So there are some grounds on which you can do testing, and one is reasonable suspicion. My opinion, and you can do random drug testing, you can do reasonable suspicion drug testing, you can do post-offer pre-employment drug testing. Again, the question is always, what do you do with that information? So let's say you've got an individual who, you're only going to have reasonable suspicion if you have the non-performance or you have some other issue that occurs in the workplace. So take action based on that issue. What happens if you've got somebody who's non-performing or who is, where there's, let's say they're falling asleep in their job or something of this sort that's violating work-related rules? You go ahead and you do the drug testing turns out to be negative. It hasn't gotten you any farther, or if it turns out to be positive, it hasn't gotten you any farther, because the issue is not whether they're under the influence of drugs. The issue is that they're falling asleep in the job. So it's a much more, in practicality, it's a much more complicated issue. Legally, they could do probable cause drug testing. The question is, what happens when you take it one step further?
So they can do it, but you can't necessarily fire them if it comes out positive.
Well, if it comes up positive, and then it becomes more complicated, because if they say that they're in a drug program, for example, you know, then they're a rehabilitated drug addict, and that creates protections under the Americans with Disabilities Act. So, you know, you're gonna avoid those issues if you act based on the performance. There are ways to get through that. We can walk through those kinds of issues. You know, there's always ways to get through those kinds of problems, but most of us want to go one step further and find out why this bad performance is occurring, why there's an issue, and it really doesn't matter. We're running a business, and what we need to do is assure that there's correct performance, I think.
Sharon, can I ask a question?
Yeah.
So most of us sit at a desk all day, right? So we're here at 8 o'clock in the morning. By 3 o'clock this afternoon, if I have to read a 60-page single-spaced document, there's a reasonable chance my eyes are going to roll back up into my head at some point.
There you go.
And I'm going to fall asleep in 5 minutes at my desk. Now, from what you were saying, it sounds like, you know, falling asleep on the job is like automatically, you know, this horrible thing that you can be fired for. I mean, what's the deal with that?
Well, the deal is, remember, you can be fired for any reason or no reason
Well,
at
that's
all.
for sure.
If I walked into your office at 3 o'clock, I would expect you to be working, not taking a nap on your couch or watching,
I was trying to work it.
or watching television. Neil has a television in his office. But this is what I love about employment law. It's like an onion. You know, you peel one layer, and there's another layer, and there's another layer, and there's another layer. So if you were just falling asleep on it, number one, I probably wouldn't fire you if you fell asleep on the job once. But if you were regularly doing it, and that happens a lot, particularly with people who work a night shift, they hide somewheres and they sleep. And I've seen it time and time again with employers that I represent.
And I will literally fall asleep sitting at my desk in the middle of a paragraph somewhere.
God bless you. I'm very thrilled that you haven't fallen asleep in my speech.
That would not be possible.
But you know, it's perfectly permissible to fire somebody for any reason or no reason at all, including falling asleep. The complication becomes if you have narcolepsy or some other sort of disability which can be accommodated, for example, by permitting you to change your hours or taking a little nap here and there or something of this sort. So these basic answers are not necessarily answers for every question because there's always a little wrinkle like narcolepsy. I want to get to the